Mr. J. Oren Ross, Esquire, is a Georgia estate planning attorney. He holds a JD and an MBA from Georgia State University and is a member of the State Bar of Georgia Fiduciary Law Section and the North Fulton Bar Association. Mr. Ross uses his years of experience as an estate planning attorney to educate clients on the potential legal, tax, and personal ramifications of different estate planning methods. His primary focus is educating his clients on their many options and helping to simplify the administration of their estates by avoiding the probate process with living trust. Mr. Ross has extensive experience with all aspects of estate planning, including revocable trust, irrevocable trust, inheritance trust, special needs trust, last will and testaments, and probate. On behalf of POOIA and Kanoon, I extend my gratitude to you for accepting to talk for us. I hope you make all these, terms clear for us. Mr. Ross will talk about wills, trust, and avoiding probate. Mr. Ross, we are all ears. Can you please?
All right. So as Ms. Varsagar said, my name is Oren Ross. I'm an estate planning attorney. I'm originally from Tifton in South Georgia. If you've ever gotten a speeding ticket going to Florida, you probably know where that is. And I came to Atlanta to go to law school and business school at Georgia State. After that, I worked for an estate planning law firm for 5 years. And in 2020, I opened my own firm. And we only do estate planning because for some things in life, you need to have a specialist. If you have a heart problem, you go to a cardiologist, not a general practitioner. And most attorneys are general practitioners. They work on several different practice areas. They don't really focus on any one particular area. And a lot of those attorneys are the people who say that they write wills and trusts for their clients. Most of those attorneys don't ever actually write anything. They have forms that they have printed off the internet. They have an assistant fill your information in, and then they hand that out to people. Most of those attorneys have clients receiving trusts that are about 8 to 10 pages long. My trusts are usually around 50 pages long because there are a lot of factors that need to be considered and a lot of contingencies that need to be built in so that even if something unexpected happens, you have a plan in place. And I got into estate planning because I've experienced what can happen when you don't have a good plan. My family has some farms in Tifton that were owned by a corporation that was owned by my grandmother, and she died in 2003. And we were going to probate her will, but one of my uncles said that we didn't have to because everything was owned by this corporation. And everyone believed him because he was a very smart man. He owned a very successful company that half my family worked for. So we all thought that he knew everything about estate planning, and we found out that he didn't know that much about it 5 years later when my parents tried to buy out my aunts and uncles. No one owned any shares yet because they were still considered part of my grandmother's estate. So we had to probate her will, and during the 5 years that everything was sitting there, a lot of my aunts and uncles and cousins had gone to her house and taken things they thought they should have because everyone knew where the key to the house was. So things disappeared over time. And then we got into a court process where we had a judge telling people that they didn't get to keep the things they took. They got taken away and given to someone else. And that created a lot of family problems because I have a large family, and some of my in-laws are very opinionated. There was a lot of sibling rivalry under the surface for a long time that I wasn't really aware of when I was growing up. And this was 2008, so a lot of people were watching their retirement accounts crash and worrying more about money than about the family. So we ended up in a court process that took 10 years to resolve because everyone got their own lawyer, their own surveyor, their own accountant. Everyone had different ideas about how things should be split up. And because we were going through this court process, we had to get everyone to agree on the final disposition of assets. So it took 10 years to settle. In the fall of 2018, when we got everything resolved, we set up a living trust for my parents, and we put the farms and their business and their house and everything that they had into the living trust, so that when they pass away, we don't have to go through the same process with my brother and my sister, because we all get along well. But when you have money and property and family heirlooms being split up, people stop getting along really quickly. All right, that's enough about me. All right, so what we're going to do today is I'm going to cover a little bit about how probate works in Georgia. If you have a will, how that works. If you don't have a will, I'm going to compare that to the most common type of trust called a revocable living trust. I'll talk a little bit about how you can avoid nursing home expenses and how you can protect the inheritance that you leave to your family. Before I get into some client stories, there's a very common misconception that a lot of people have. A lot of people think that when you have a will, that you don't go through probate. People always assume that you just go to a lawyer's office, the lawyer reads the will, and people leave with their money. That's not how it works. That's only on TV. So in reality, a will just directs the probate court as to how you want your probate to go. It's designed to go through probate. So when someone passes away and they have assets titled in their name, probate is the process to take their name off that asset and give it to their heirs. So we have to do that if someone is the only name on an asset. But in Georgia, a lot of assets that are titled to more than one person also have to be probated. So when we have someone die with a will, the first step is that we have to validate the will. If we can't validate it, if it's not valid on its face, which is the case with a lot of wills from other states, then we have to try to find the witnesses who watched that person sign the will and have them testify for the court. We have to have all your legal heirs sign off on all the paperwork, not just the people that you want to leave things to. We have to publish notice in the newspaper for 4 weeks. After that, we have to wait another 3 months for creditors to come forward so they can get paid before anyone else does. We have to file inventories and accountings of all the assets in the estate. And we have to allow people to contest the will. So it's a long process, even for what people assume should be a straightforward estate. If you don't have a will, or if we can't validate it, we do something called the intestate process. And the state has a family tree that they use to decide who gets your assets. So many people assume that if you pass away without a will, that everything would just go to your spouse, but that's usually not the way that it works. So if you are married and you have 2 kids, and you die without a will, your spouse would get 1/3 of your assets, and each of your children would get 1/3 of your assets. That's not ideal, especially if you're on a second marriage, because then your current spouse gets 1/3, your children each get 1/3, and usually the children will force the current spouse to sell their house and liquidate assets so they can get their money out of the estate. So at a minimum, you want to have a valid will that directs where your assets would go if you were to pass away. So we had a client 2 years ago who came in to probate her dad's estate. Her dad had, before he passed away, he'd gone to his lawyer. He had a will drawn up. He left everything to this lady, Anna, and her brother, and he made Anna the executor of the will. So he ended up getting sick and passing away. So she went to their local funeral home. They set up the funeral and the burial, and they told her that it was going to be about $14,000 for everything that he wanted. And she didn't have that much money in the bank, but she knew that her dad did. He had accounts at a few different banks. He had a brokerage account. So she said, let me go to one of my dad's banks. I'll pull some money out of his account and I'll come back and pay for everything. So she went over to one of her dad's banks. She spoke to a banker. She showed him the will. She said, I'm the executor of my dad's will. I need to pay for his funeral. I need to get some money out of his account. So they went to the banker's office. He looked up the account and he said, I'm sorry, but your dad's account is frozen. I can't give you any information on it until you probate your dad's will. And she didn't know what that meant because no one had ever explained this process to her. So she got frustrated. She went to the next bank and they said the same thing. The accounts are frozen. And the next bank said the same thing. And then she went to her dad's Edward Jones advisor. She tried to access his brokerage account. He said, I'm sorry, but your dad's account is already frozen. And she couldn't figure out why everything was frozen. But when you pass away and you end up in a morgue or a funeral home, they flag your social security number so that banks and brokerages know that you've died so they can freeze your accounts so no one can steal your money. So the guy at Edward Jones told her that he said, my clients usually get a lawyer. The lawyer will take your family through this court process called probate. Once you get into that probate, they'll give you some court orders. You'll have to bring one of those back to me, and then I'll send it to our legal department in St. Louis because they decide what happens with your dad's money since the account is frozen. So she couldn't access any of his accounts. So she went back to the funeral home. She used her credit cards to pay for everything. And she was really worried about how she was going to cover all of those costs. But 2 days later, at her dad's funeral, a man came in and he said, I was friends with your dad for about 50 years. And I know this is not a good time for me to bring this up, but I really want to buy your dad's house. I've always liked his house. And my daughter's moving to town next month. She needs a place to live. So if you're willing to sell it, I could pay you cash for it. So she thought that that was going to be the answer to all her money problems. So they agreed on a price. She said, let me get my dad buried, and then I'll call the title company for the house and we can set up the sale. So after her dad was buried, she called the title company for the house. She spoke to an attorney there. She said, I'm the executor of my dad's will, and I found a buyer for his house. We've agreed on a cash sale of $500,000, and I want to close as soon as possible. And the attorney said, it's good that you found a buyer, but the title to your dad's house is frozen. You can't sell it until you probate his estate. So you need to probate his will. And once you get permission from the probate court, you can call us back and we can set up a sale. So she didn't know what else to do. So she eventually called her dad's accountant, and then he suggested that she call us. So when I talked to her, I said, there's usually about 10 or 12 steps in this probate process that we have to go through to close out your dad's estate. And the first step is getting you appointed as the executor, because even though the will says that you're the executor, that doesn't mean anything until the probate court appoints you. So we have to put together some paperwork. We send that to all the different creditors and heirs who need to sign off on it. And when we get that back, we can file it with the probate court. And it always takes a while to get all that information together. Usually takes a while to get the heirs and any necessary creditors to sign off. So we got the initial set of paperwork back 3 months after her dad had passed away. And then we filed it with the court. And 2 months after that, we got orders from the court. So we got something called letters testamentary. So I said, you're going to take these letters testamentary to the banks, to Edward Jones. They'll send those to their legal departments. And if everything looks okay, they'll move your dad's money from those frozen accounts into new estate accounts. But the banks are never really all that willing to let money go. They don't want to move it into new accounts. So it took about a month to get all the accounts switched over. Once she had the estate account set up, I told her that she could sell her dad's house. So she called her dad's friend, and when she called him, he said, I'm glad you called. I thought you forgot about me. It's been almost 6 months since we talked at your dad's funeral. And she said, I know it's been a while, but we've been working with a lawyer. We got my dad's estate set up, and they said I can sell the house to you now. So if you're still willing to buy it, I'd like to sell it to you as soon as you can write me a check. And he said, I'm glad everything's working out for you now, but I don't need a house anymore. My daughter moved to town 5 months ago, and you wouldn't answer my phone call. So we bought a house down the street from us. So I hope everything works out, but I don't need any more houses. And she was really mad that she lost out on that cash sale of the house because we can't close out her dad's estate until she finds a buyer for the house. She gets the sale approved by the judge. Then they can sell the house. After that, the money has to go into an estate account. And then we have to file accountings with the court to show how she's handled everything. We have to account for every dollar along the way, show the judge where everything went. And then if all that looks okay, then the judge will issue a final order that says that after all the costs of the estate have been paid, so after all the creditors get paid, after all the attorney's fees, and after all the court costs, then whatever is left in the estate can be distributed to Anna and her brother. So that's what probate is. It's when you pass away, if there's something titled in your name, the court oversees the distribution of these assets, making sure that the executor does what the will required them to do. So we always get two main questions about probate. Everyone wants to know how long it will take and how much it will cost. It's very hard to say how long a probate will take because a lot of that depends on your estate and your family. But the average probate in Georgia is about 12 months. The closer you get to Atlanta, the longer that tends to take because the counties are so overpopulated. 12 months is about the average. But if we have one person or the spouse of a person who isn't completely cooperative, then everything freezes up. We have to have court hearings and drag everyone into court to explain things to the judge and try to get things back on track. So 12 months is the average. But if there's one person who isn't completely cooperative, that it can easily take 2 to 3 years. As far as how much a probate will cost, that's also a hard answer to give because a lot of that just depends on largely on your attorney and how much work there is in the estate. Part of the problem with Georgia is that as far as the attorney's fees for probate go, we don't have a real standard. So in a lot of states, there is a percentage cost for the attorney's fees. There's a percentage that is paid to the court, and there's a percentage that is paid to the executor. For the attorney's fees in Georgia, we have something called a reasonableness standard. So as long as the cost can be claimed as reasonable, the attorneys can charge whatever they want. So we usually charge hourly for probate work in Georgia. It's usually somewhere around $300 an hour for out-of-court work and about $400 an hour for court time. And because we have a standard that doesn't really mean anything, people can be taken advantage of. In states where they have a fixed cost, the attorney knows exactly what they're going to make off that state, so it's in their best interest to push it through the court system as fast as possible so they can get paid and get to another client to be paid again. But in Georgia, where we work on hourly rates, it's in the attorney's best interest for this to take as long as possible because the longer it takes, the more money they can charge the estate. So I don't have any proof of this, but I think this is why a lot of attorneys give out free wills or very cheap wills. It seems like they're doing you a favor, but I think they're just setting up future business because they know that when you pass away, your family will come back to them to probate your estate because people always assume that they have to use the lawyer who wrote the will. You can go to any lawyer that you want to, but people assume that we have all of that person's information. So they think they have to go back to that lawyer. So if you give out enough wills, people start passing away and then they come back to you and you can charge them your hourly rate to go through this court process. Some people do get taken advantage of. We were working with a lady last year to set up a trust, and her husband passed away a few years before that. And when her husband passed away, she wanted to sell their house because it was too big for her to manage by herself, but she couldn't because even though he had a will leaving her his half of the house, she couldn't sell it until she probated his will because Georgia is not a community property state. You don't automatically inherit your spouse's half of your house. They are free to leave their half of your house to whoever they want. There is something called joint tenancy with rights of survivorship that you can have written into a deed, and that allows the surviving spouse to automatically inherit the other half of the house. But the problem with joint tenancy is that it only works when that first spouse passes away. When that surviving spouse passes away, we still have to probate the estate. And it doesn't work that well for second marriages because if you're on a second marriage, you pass away, your half of the house goes to your spouse. You're basically disinheriting your children of your equity in the house. But this lady, like most people, they just had his name and her name on the deeds. So they each owned 50% of the house. So his 50% was frozen. She had to probate the will to sell the house. And they were friends with a well-known probate attorney in Roswell for 30 or so years. So she thought that he would be a good person to probate her husband's estate. So she said that she knew he had a high hourly rate, but she didn't think there was that much work to do. And she thought since they'd been friends for 30 years that he wouldn't rip her off. So they signed a contract. They got everything filed. They were wrapping everything up 8 or 9 months later, getting the house and a couple accounts transferred over to her name. And she said she went out to the mailbox one day and there was a bill in there from his office for $12,000 for that 8 months or so of work. And she felt like he took advantage of her, and he probably did. But that's really hard to prove because reasonableness doesn't really mean anything. All that means is more likely than not. And as long as an attorney can make a reasonable argument to a judge that they were working on the estate, which is not all that difficult because the judges are also lawyers who used to do the same work that we do. Then the judge will sign off on it, and then the estate has to pay those fees before anything can be paid to your heirs. And a lot of people don't really understand how hourly rates work with attorneys, but you almost never get billed in terms of actual time. You get billed in increments of an hour. So 6-minute increments or 10-minute increments. Some firms use 15 minutes. You're not supposed to round up, but most lawyers do when they're billing people, because if you have a 2-minute phone call with someone, you can say that you were making notes on the file for the other 4 minutes, or you were reviewing the file, and there's no way that anyone can ever prove that you weren't doing it. So as long as you don't do something crazy, like say you were making notes for 2 hours because of a 2-minute phone call, you can pad these hourly rates, and there's nothing that anyone can do about it. So if you have a $300 an hour attorney, 15 hours of work is $4,500. So these costs really add up, and people don't see it coming because they assume that the estate will be very straightforward. And it's really easy to find out what all the probate costs are, because when we have a probate, all of your assets get listed out. All of your property values, all your account values, all the debts that you owe, all the expenses that your estate pays, all the distributions to your heirs get listed out in the inventories and accountings that we have to file with the court. And when we file those with the court, that means they are in the public record, and now they're posted on the internet. So it's very easy to go through people's estates and find out what they were worth, who they owed money to, and who received their assets. So it's pretty common for there to be somewhere around $6,000 or $8,000 in just attorney's fees when someone passes away and we probate their estate. And if you're a married couple, your family almost always has to go through that probate twice. Once when that first spouse passes away to take their name off of everything, which is usually an easier process because most spouses have joint bank accounts. Maybe they have joint tenancy on the house. But the real issues come into play when that surviving spouse passes away and we have to completely retitle assets, and we usually have more than one person involved. It gets more complicated and more expensive. In 1990, AARP published a study on the attorney's fees for probate, and they said that probate is a cash cow for lawyers. They said that somewhere between 5 to 10% of the total value of an estate on average was spent just on the attorney's fees for the probate, and that smaller estates had a proportionally higher cost than large estates. And they said the total cost for the attorney's fees for probate would be about $25 billion a year in 1990. That would be about $125 billion a year now. But that number has probably gone up because the legal system has not gotten less complicated in the last 30 years. In Georgia, we've had 2 major updates to the probate code since 1998. So there are a lot more steps that we have to go through, more hoops that we have to jump through to get an estate closed. And the population of Georgia has increased exponentially. But even back in 1990, AARP recommended that you try to avoid going through probate with something called a revocable living trust, like we set up for my clients, Larry and Linda. Larry and Linda came in about 3 years ago, and when they came in, Linda had one of the crazier stories about her mom's estate. She said that her mom had died 3 years before that, and she'd had a will. She said that her brother was named as the executor, and that he wasn't the most honest person in the world. And she said that he had hired one of his friends to be the lawyer for the estate. They'd spent about $15,000 in attorney's fees so far, and she had not received her inheritance yet. And no one could explain to her why the money was still sitting in her mother's estate. And she thought that he and his lawyer were conspiring to do something illegal with her mother's money. And she said, we don't want the same process to happen with our children. So all we want is to set things up so that if one of us passes away, the other spouse just stays in control of everything. And then if both of us pass away, we want everything to go to our 3 children immediately, but we want our daughter Becky to be the one in control of that. So they'd been to one of the seminars that I do, so they understood that if one of them passed away and there was something titled in their name, like their house or their brokerage account, then that asset would probably be frozen, and we'd have to get that surviving spouse and maybe their children to come into the office, go through the probate process, and when that surviving spouse passed away, we'd have to do it all over again. But they also knew that if their things were titled in the name of a living trust, then nothing would ever be frozen. No one would have to show up for court. Everything would remain private, and we could have their daughter Becky start wrapping things up the day that they passed away without the expenses and hassles and delays of probate. So we set up the Larry and Linda Living Trust. So their trust was a revocable living trust. So with this revocable living trust, it says that while they're alive, they can do whatever they want with these trust assets. They can buy or sell or spend anything that they want. It doesn't change anything about your day-to-day life. So you still file your taxes the same way. You still get your homestead exemption. You still get your senior exemption. We're just changing what happens when someone dies. So since it's revocable, you can change this trust at any time that you want. But if one spouse passes away, everything stays under the control of that surviving spouse. So then the surviving spouse can buy or sell or spend whatever they would like. We do change that part sometimes if you're concerned that your surviving spouse might get remarried and change things, or if you think they might spend too much money. So most couples have what's called a sweetheart will, where you leave everything to your spouse, they leave everything to you. When you both pass away, it goes to your children. That works okay for some people, but especially if you're on a second marriage, that's probably not the best option, because if you have a will like that, you leave everything to your spouse, they can change their will at any time. They can cut your children out completely. And they don't always do that on purpose, but a lot of times people will get remarried. They have a new will made with that new spouse, and then they pass away, and all of your assets go to that new spouse who never knew your children. But even if you have a will that says that everything goes to your children, it doesn't leave anything to your spouse can file something called a year support motion and take your entire estate anyway. So if you're on a second marriage, it's very important to keep your assets out of probate, because there are tricks that lawyers can use to pull money to a spouse who was not supposed to receive something. But with a trust, we can say that that surviving spouse can still live their life normally. They just can't change who the beneficiaries of the trust would be. So they can't cut anyone out. They can't add anyone new. Or we can limit their access to assets, or you can have some money go to your children early if you pass away, or you can even have completely separate trusts if you want to keep your assets separate. But for Larry and Linda, that wasn't a concern. So in their trust, it said that if one of them passed away, the surviving spouse would still have complete control and access to their assets. The trust also said that if both of them pass away, then their daughter Becky is the successor trustee. So it's her job to step in, pay any final expenses, and split up the estate. So the successor trustee is usually one of your children, or more than one if you want to have co-trustees, but it doesn't have to be. It can be anyone. But to avoid probate with something like a revocable living trust, you have to retitle assets into the trust. So when we were setting their trust up, Larry and Linda were pretty sure that Larry was going to pass away first, because he was sick, and they wanted to make sure that if something happened to him, that Linda would be able to sell their house immediately. So we retitled their house into their trust. So before, it was just titled in their names, and after we were done, it was titled as Larry and Linda as trustees of the Larry and Linda Living Trust. So we titled their house into their trust. They put their accounts into their trust. And about 3 months after we had everything set up, we got a call from Linda one day. And she said, my husband, Larry, died 2 days ago, and I'm trying to figure out how to put our house up for sale. But my neighbor told me it's going to be a while before we can do that, because when her husband died, she had to probate his will to sell their house. And she said that I've got to do that too. And I said, what your neighbor doesn't know is we set up a living trust, and I titled the house into the trust for you. So I know he only passed away 2 days ago, but if you could find a buyer for the house today, you could sell it today. So it only took her about 2 weeks to find a buyer and close the sale. And then she was able to move to be closer to her grandchildren. So transferring real estate into a trust is something that we always do when we set one up. Real estate is one of the things that really slows a probate court down, because when we have to get judicial approval for a sale, buyers don't want to wait a couple of months hoping that a judge is going to approve it. So we'll go through several potential buyers before we find one who's willing to wait. And that's especially important if you have property in more than one state, because no state has jurisdiction over property in another state. So if you live here and you have a beach house in Florida, that means a second probate in Florida. If you have a mountain house in Tennessee, that means a third probate in Tennessee. But we can retitle real estate in any state into a trust that you set up here, and you can avoid every probate in every state. That only works for U.S. property. We cannot transfer property held in another country into a U.S. trust. We can only put property that is governed by U.S. law into a U.S. trust. So we also have to retitle things like after-tax investments. So Larry and Linda had a brokerage account at Merrill Lynch. So I told them to retitle their brokerage account into the trust, because before they just had their names on the account. And if that had been the case when Larry passed away, they would have frozen the account, or at least half of it, because brokerages don't want to be liable for money going missing during a probate. So they'll just freeze it until they get a court order. But because they had retitled this account into their trust, it was titled as Larry and Linda as trustees of the Larry and Linda Living Trust. When Larry passed away, Linda was still the trustee of the trust, so she still had full access to their account. So we have to retitle most assets that you have into a living trust when we set one up. So things like brokerage accounts, bank accounts. We want to retitle everything that you have at a bank into a trust. We want to put all of your real estate into a trust, any savings bonds, basically any accounts that you have that are not retirement accounts. If you own a business, we also want to retitle that ownership interest into the trust. And if you do own a business, you can write off the cost of setting up a trust as business succession planning. And then if you have anything that's reasonably valuable, like jewelry, art, china, silverware, tools, guns, we retitle all those things into the trust. You don't have to itemize or inventory anything. We just say that the jewelry collection is going to the trust, or the art collection is going to the trust, because the probate court wants to oversee anything of value. But there are some things that you don't have to retitle into a trust. Larry and Linda both had IRAs, and on their IRA paperwork, Larry had named Linda as the beneficiary of his account. So when he passed away, she just had to submit a death certificate to the IRA company, and they wrote his IRA over to her. An IRA is one of the 4 basic types of accounts where you can name a beneficiary for it, and it's designed to avoid probate. So IRAs, 401ks, really any retirement account that you have, life insurance, and annuities are all designed to avoid probate. They're not supposed to go through that system. As long as you have a beneficiary named on your beneficiary form, it goes to that beneficiary. But that only works if you have someone named on the form. So you want to make sure that you have your spouse as your primary beneficiary, your children as your contingent beneficiaries. And then if we set up a trust, you can name the trust as the last possible beneficiary, because a trust cannot die. So even if something happens to everyone else, it would be there to catch that money and distribute it to your family. So as far as their checking account, Larry and Linda wanted to know what they should do with that. You have 3 basic options to keep something like a checking account out of probate in Georgia. The best option is to make the account a trust account. The way that you do that is by giving something that we put together called a certification of trust to your bank. They keep that in their records, and that's what makes the account a trust account. You don't need to get new checks. You don't need new accounts, because a trust just latches onto your current accounts. That's the best way to do it, because the day that you pass away, your successor trustee can access your account to pay final expenses and start splitting things up. Larry and Linda didn't do that. They did what some people do, even though I tell people not to do it. They took their daughter Becky to their bank, and they added her as a signer on their account. Because with a bank account, as long as you have one person alive on the account, it is not frozen. So when the parents had both passed away, Becky was able to write checks and pay expenses on the account, but there are several reasons that you should not do that. Number one being that when you add someone to an account, they can access your money immediately, but so can anyone they owe money to. If someone sues them, their creditors can attach your account to that lawsuit, because if they can access that money, that is their money too. They also are not required to share that money with anyone else. If they pass away, that account still has to be probated. And when you add someone as a signer on an account, the IRS considers that a taxable gift. So if you don't file a gift tax return, they start looking a lot closer at your taxes. So there are several reasons not to do that. The same concept applies to real estate. Sometimes people will add their children to the deed to their house to avoid probate when the parents pass away. But when you do that, you are destroying the step-up basis for capital gains tax. If your children inherit a property from you, they receive a stepped-up basis for capital gains tax. So if they sell it after you pass away, they don't have to pay anything in capital gains. But if you add them to the deed with you, they have to pay capital gains tax from the day that you bought the property. So it almost always ends up costing more in taxes if you add your children to the deed to your house. And then the third option for bank accounts is something called a POD form, a payable on death form. Some banks will let you name a beneficiary for a bank account if all of the owners pass away. POD forms are not foolproof. They're also known as TOD forms when it's for a brokerage account, but those are not foolproof. They can be pulled into probate by creditors or heirs. If you have medical bills when you pass away, they will go after those accounts because that account was in your name when you passed away. It's fully visible and it can be pulled back from your heirs. So with POD forms, we also have some of the other issues that we have with just naming a child on an account. They are not required to share that money with their siblings. And if they pass away, the account still has to be probated. So the best option for bank accounts is to make the accounts trust accounts. And then the successor trustee cannot access the account early. It is not considered their money. But when the parents pass away, the successor trustee can use that account to pay final expenses and split the assets up the way that the trust requires that they be split. They also wanted to know what they should do with their cars. Cars are a little bit different because we almost always leave cars outside of a trust while you're alive, and those are covered by something called a pour-over will. Anytime we set up a living trust, you still need a will because a will is the basic estate planning document, but this kind of will is called a pour-over will because it is there to pour over the residue of your estate to the trust after you pass away. So we mainly use it for cars. The reason we leave cars outside of the trust is because if we transfer your cars into your trust, you will be charged ad valorem tax again. And if you have a wreck and a lawyer sees that a trust owns the car, they start looking into your personal assets. So we try to leave cars in your name so that they just go after your insurance company and don't look into you personally. But the pour-over will is there to cancel any previous will and leave the residue of your estate to your trust after you pass away. So with Larry and Linda, we had everything titled correctly. So when Larry passed away, Linda was still able to access their accounts. She was able to sell their house in about 2 weeks. And she moved to be closer to her grandchildren. And she was living near her grandchildren for about 10 months. And then one day we got a call from their daughter, Becky. And she said, my mom passed away a week ago, and I've been trying to figure out how to close out their estate, but I've been having some issues with my brother. She said, both of my brothers know that there was about $600,000 left in my parents' brokerage account when my mother died. And she said, my brother in Florida married this woman a few years ago, and she can't stand us, and we hate her. So she said, he's been calling me twice a day, demanding his share of the account, and I don't really know what to tell him. So I said, all you have to do is call Merrill Lynch, where the account is. As soon as they find out that your mother has passed away, they have something in their records that your parents gave them called a certification of trust. It says that you are the next trustee. So they'll give you access to the account and they can help you split it up. So she hung up and she called back a couple days later and she said that they just created 3 new accounts, one for each of the children. They split the parents' account into 3 equal accounts. It took 2 days and didn't cost anything. And she was very happy that it was easy to do because she said her brother in Florida had called her again that morning to thank her for getting everything resolved because he doesn't trust Becky and he wanted to make sure that his wife was able to access her $200,000. But now that he and his wife have gotten their $200,000. She's a much nicer sister-in-law to have. And unfortunately, that's the way that these things tend to work out. I talk to people every week who swear that their kids all get along, their in-laws all get along, no one has any money problems, there won't be any issues. That's almost never the case, but even if it is, people do not act rationally when their parents pass away. I've met the most level-headed people who, when their parents pass away, cannot form a sentence. They can't bring themselves to open the book that we give them with instructions. They just need someone to hold their hands for a month or two until they get things together. So that's why ideally I like to set up these revocable living trusts so that even if someone does have an issue, even if there is a disagreement, that can be resolved in a conference room and not in a courtroom with multiple lawyers being paid. So that's a revocable living trust. With that kind of trust, you can change anything that you want at any time. There are a lot of other different kinds of trusts. Most of those are irrevocable trusts. One of the kinds of irrevocable trusts that we set up for some people is called a Medicaid irrevocable trust or a Medicaid asset protection trust. It has different names, but basically it's an irrevocable trust where we can protect your assets from future nursing home expenses. We set one of those up for a lady named Betty 6 years ago. When she came in, she had a house that was worth about $350,000. She had a savings account and a brokerage account that was worth about $450,000. She had 3 children, and it was important for her to be able to leave them something of an inheritance, but she was worried because her neighbors had gone into a nursing home before that, a few years before that, and she heard that they'd spent their life savings of $400,000 on their long-term care, and she heard that they might lose their house too. So we started covering the Georgia long-term care Medicaid rules. So I said, if you own this house and you have these accounts, and at some point you end up in a nursing home, they will make you spend your $450,000 down until you have less than $2,000 left. And that sounds impossible, but the average nursing home cost in Georgia is about $8,000 a month per person. That doesn't include medical expenses. So it can easily be $10,000 or $15,000 a month, depending on where you are and what care you need. And once all of your money is gone, once you have less than $2,000 left, then Medicaid will kick in and start paying for your nursing home and medical expenses. And after that, they can't take your house from you while you're alive. But when you get on Medicaid, they can put a lien on your house so that when you pass away and your house is sold, they can take the money from the sale to reimburse Medicaid for what they paid for you. So they can take everything eventually, but they can't take your house from you while you're still alive. And she wanted to avoid that. So we started talking about a Medicaid trust. So I said, if we set up a Medicaid trust for you, we would put your house into it. We would put your savings account into it. We would put your brokerage account into it. You are the trustee of that trust. You still control those assets that are in the trust. So if you want to sell your house and buy another one, you can. If you want to move your investments around, you can do that. We leave a checking account outside of that trust, and that checking account is where all of your income goes. So your Social Security money, IRA distributions, any money that you have coming in goes to a checking account that's just in your name. You can spend that money on whatever you want. But everything that we put into the trust has to remain in the trust. You cannot spend that money on yourself. But if at some point your income does not cover your expenses at any time in any amount for any reason, you can make a distribution from your trust to one of your children, one of your heirs, and then they can pay your bills for you, or they can just give you the money to spend. You cannot take assets from that trust and give them to yourself, but you can take assets from that trust and give them to your children. Once they go to your children, if they want to pay for your expenses or if they want to give you money, they are free to do that. So that only works if you trust the person that you're going to send the money to, because they have every right in the world to keep it. This is basically an early inheritance. If you make a distribution from that trust to your children, that's basically part of their inheritance. So they have a right to keep it, but they can also spend that money on you if they want. She trusted her daughter, so she didn't think that that would be an issue. The other issue that we have with these Medicaid trusts is that there's a 5-year look-back period. Medicaid can look back 5 years into your finances to see if you've transferred money out of your name. And if you have, they penalize you so that you can't qualify for Medicaid. So you never want to apply early. If we set up something like a Medicaid trust, you always want to wait until you get past that 5-year mark in order to apply for Medicaid. If you set up a Medicaid trust and then you need to go into long-term care 4 years after that, you would need to be a private pay patient for that one remaining year. And then once you get to 5 years, you can apply for Medicaid, and they can't count those assets as yours. So that 5 years is a hard rule. We'd never want to apply early. The penalty would be the same whether you apply 1 year later or 4.5 years later. So you always want to wait until you get past that 5 years to apply. So Medicaid trusts are not for everyone. They also don't really work that well if you have a lot of your money in retirement accounts, because IRAs and 401ks cannot be transferred directly into a trust. If you want to put that money into a trust, you have to take it out, pay the taxes on it, and then you could reinvest it into a trust. But that usually doesn't make that much sense because you would pay a ridiculous amount of money in taxes. So if you have a lot of your money in retirement accounts, a Medicaid trust doesn't make that much sense. So there are other options. There are things like long-term care insurance. Now there are hybrid life insurance policies with long-term care riders. So there are different insurance options to try to avoid that cost. But you can also just pay for things yourself. If you aren't that concerned with long-term care expenses, if you're worth $2 or $3 million, then it's pretty unlikely that a nursing home stay would just wipe out your estate. But I have had several clients spend $500,000 for the care for one person. So it's important to consider how those costs can add up, especially with things like dementia and Alzheimer's. The costs really tend to skyrocket. But that's a Medicaid trust. That's an irrevocable trust. So once we set that up and put assets into it, we can't just take it back. So I really don't set up these Medicaid trusts unless you absolutely know that you need it. Usually what we do is we can start with a revocable living trust. And then if at some point you determine that you need a Medicaid trust, we can convert the revocable trust into the Medicaid trust, but we cannot go the other way. So you never want to set up that irrevocable trust unless you know that you need it. All right, so that's enough for the Medicaid trust. So in addition to these living trusts, so the revocable living trust and the irrevocable Medicaid trust, we have trusts that we use to protect the inheritance that you leave to someone. So there are two main trusts in that vein. There are inheritance trusts and special needs trusts. So an inheritance trust is what we set up for most people. Not everyone needs a special needs trust, but an inheritance trust has three main benefits. The first being that we can divorce proof what you leave to someone. It doesn't say that's what it's for. It's not specific to any spouse. So if they're married now or if they get married later, it does not matter. They can be married 10 times in between now and then. Money or property that you leave to that person is not held in their name. It's held in the name of their inheritance trust. So if they get a divorce at some point, their spouse cannot claim anything in that trust as marital property because it's not actually theirs. It's held in the name of a separate trust that we can give them control of and they can be beneficiaries of, but it's not actually their money yet. The second reason that we use those is because we can keep things in your family even if someone passes away. So if you leave money to one of your children and they pass away, that inheritance trust says that their spouse does not receive anything. Their children are the next beneficiaries of that trust. Or if they don't have children, we send it to their siblings or a charity or wherever you want it to go. We just generally try not to leave it to the spouse because they usually spend that on their wedding to the next person. The spouse can be a beneficiary if you want them to be, but that's usually not the way that we set them up. And then the third reason is because you can control how much they get and when they would get it. So we set one of these trusts up for my oldest nephew, who is turning 15 this month, because he wants to be a YouTube star. So we all know that he's kind of an idiot. So his parents wanted to make sure that if something happens to them, that he doesn't get a lump sum of money when he turns 18. So we set up an inheritance trust, and they said that he can have full access to his money when he turns 30. before he turns 30, that money would be held in trust for his care. So it's there for his basic needs. And then once he gets to that age, he can have full access. But the trustee, which would be me, would also have the discretion to pay for anything beyond that. So if I think that he should go on a trip, I could pay for the trip. If I think he should have a car, I could pay for the car. But he can't just demand money out for these random things. So we can have different distribution schemes for these. So if you set those up for someone who's completely responsible, we can say that they can have full access to everything when they're 25. If they're over 25 already, then they would have full access. But if something happens to them, then their children would not have access until they turn 25. Or you can say that they would receive different percentages at different ages, or monthly amounts or yearly amounts. You can set that up pretty much any way that you want to. But those are a very important part of estate planning, because there's no reason to leave money to someone if they're going to blow it overnight, or if they're going to lose it in a divorce. So I include one of those inheritance trusts for free as part of the living trust package that we set up for people. And then the other kind of trust for the children is a special needs trust. With a special needs trust, you can leave as much money as you want for the care of a special needs person, and it will never kick them off their government benefits. The way that that trust works is that they cannot be in control of their own trust. Someone else has to be the trustee for them. That's usually a sibling, but that trustee can use those trust assets to pay for anything beyond what the government benefits cover. So the government benefits cover very few things, very narrow window. The trust assets can be used for anything beyond that. And because the trust says that we are not crossing over into what the government benefits cover, we can keep the benefits and the inheritance. So that's very important to have, because if you leave money to someone who has special needs and receiving SSI or Medicaid assistance, they will be kicked off their government benefits and have to spend those assets down before reapplying for any assistance. And those are usually very expensive. They're usually around $5,000 or $6,000 each. So I also include one of those as part of our living trust package if it's needed. And then one more thing, powers of attorney. Everyone over the age of 18 needs powers of attorney. You do not have the ability to make decisions for your adult children just because you are their parent, and you do not have the ability to make decisions for your spouse just because you are married. So you need powers of attorney. There are two main types. There's a financial power of attorney, and there's a healthcare power of attorney. The financial power of attorney for Georgia was updated in 2017. So if you have one from before 2017, or if you have one from another state, you need to have it updated, because these are state by state. Every state has their own rules and their own laws. This is where you name a financial agent who can pay your bills and manage your money for you if you're unable to do that for yourself. And then with the advanced directive for healthcare, the healthcare power of attorney, that was updated in 2007. That's where you name a healthcare agent who can speak to your doctors and consent to surgery. And that also includes the living will, so you can decide what happens if you're ever on life support, or if you have a terminal condition, so that your family doesn't have to try to decide that for you.